the professor? Hey, we got you there, Professor Green.
Good to have you on the phone here. I think something went goofy with my microphone.
Well, that's no problem. Glad to have you. We were just kind of introducing the topic of this ballot initiative measure that is being deliberated by the state legislature. Of course, to kind of level set for our audience, we presently have one prescribed by the state's constitution, but it was in effect nullified by the state Supreme Court because of some mathematical imperfections in the provision, and so we stand now without such a way for citizens to get something on the ballot that they feel strongly about, that they could vote, and in this case, the measure that's being discussed and considered would actually either, I guess, amend or establish statute law and not amend the Constitution as in accordance with the old process. What do you think?
That's right.
What do you think about provisions in the measure that would limit it to only certain subject matter and perhaps prohibit other topics, such as abortion, from being considered and being available to citizens to take to the ballot?
Well, so a power to adopt a statute by initiative is just inherently very different from a power to amend the Constitution.
Okay.
So we actually have a crazy long, complicated history of this. In 1916, we attempted to adopt both of these in the state constitution, and the Mississippi Supreme Court initially said that was okay, but then in 1922, they said that these were too different from each other, so it is actually adopting two proposals at once, and you can't do that. So then in 92, we adopted just the power to amend, but of course it has the self-destruct mechanism inadvertently put in perhaps about the number of congressional districts. The thing they're talking about now, well, one thing is big difference, they would have a lot more signatures. So a couple 100,000, it's really hard to get that many people. It's not impossible, but essentially what you get when you have the power to adopt a statute, first you get the opportunity to put something on the agenda of the legislature. And then also it allows certain coalitions to preserve it. So if you had like a majority of one house of the majority of the Senate plus a majority of the electorate, well then you can pass an initiative and you can prevent any legislation to repeal it. Similarly, if you had the governor on your side and you had at least a third of one house to prevent the veto from being overridden, you could do that. So essentially, I think this would allow a workaround in certain circumstances where you've got gridlock. So then you have a question, okay, does it make any sense to limit it to certain subjects? If you thought that this kind of limited workaround for gridlock was really only something you wanted to allow for certain subjects, you could do that. So the Supreme Court has said in a case, Schuette versus By Any Means Necessary, they said you're allowed to constitutionalize certain subjects, even if you're not constitutionally obligated to have that kind of system. You can constitutionalize, in that case, affirmative action questions. They say you can't allow a legislature to do it. There have been some questions before the Schuette case of whether you could do that, but I think it would be constitutional, certainly, if they put a limited initiative. And the more the signatures are, the more limited it is in any event. But also, because it's only a power to adopt a statute, it's something that if you've got both houses of the legislature and the governor against you, it's not going to make any difference. For certain things, you could imagine, getting 50% plus one of the electorate, and it has to be very highly energized to get this couple 100,000 signatures, but you could imagine it making a difference.
Yeah. So to what extent does just the concept, Professor, of a citizen-initiated ballot measure that would enact or amend statute, to what extent does that conflict with the original framework of the U.S. Constitution, which, of course, lays out a republic form of government. Is there a conflict there? Do we look more like a democratic form of government, I guess?
Yeah, historically, you find these kind of arguments getting made. So initiatives, they get much more popular in the 19-teens. So we adopted in 1916. There's an argument that gets made at the U.S. Supreme Court, actually. So we have Article 4, Section 4 says we've got to have a Republican form of government. Historically, there's a lot of people that say that means inherently representative government.
Okay.
So you're not just going to have the legislative power given to the people at large. It's got to be people who get together and think, have a conversation. So Edmund Burke has this line saying, I owe my constituents not merely the duty to follow their will, but the duty to exercise my own judgment. I'm supposed to do what's good for my constituents, not just what they tell me to do. So historically, there is this argument against the initiative in general. Of course, we adopt all of our constitutional amendments anyway by a vote of the people.
Right.
So we've had, ever since we started having a state constitution, we have at least some element of ability to make law by the people itself, meaning, 50.1% of the people. And, there's always a choice, I think, between people who know what they're doing and kind of the concern that you have laws made by people who don't know anything, and the concern that laws are getting made by people who are just feathering their own nests.
Yeah.
So you kind of have, it's not quite as coarse-grained as kind of ignorance versus corruption, but which of these are you going to be more concerned about? Which risk is greater?
Yeah.
And at different times, I think it's going to be different. In different subject matters, it might be different. So
Sure.
if you think ignorance is a bigger danger for certain subject matters, you might say, yeah, let's leave that with the legislature. If you think corruption is a bigger deal, you want to adopt a rule that, I don't know, you can imagine, just naked suppression of competition. You get some of these statutes getting considered by the legislature all the time. You can imagine that be the kind of thing. It's really important to allow the people to rise up and say, no, dang it, we're not going to allow you to just suppress consumer choices. We want lower prices and higher production. And the idea that lower production and higher prices is the way to prosperity. It's a disturbingly tempting idea that many people have succumbed to over the years.
Sure. All right. So here's another question. This high signature threshold, is there anything in our Constitution, the state Constitution, that prescribes that, or does it prohibit the number of signatures or I guess anything related to that in the Constitution, or does the legislature have full discretion over that?
I think this is something that, whatever the proposal is that they put in, they can set the number.
Okay.
They could say, hey, if 90% of the electorate come and demand some particular kind of statute, okay, then you can do it. But anything less than that, we'll just handle all the legislating for ourselves. Thank you very much.
Yeah.
They're free not to have it at all. We don't have it. We haven't had it since 1922. If there's no constitutional requirement to have it, once in a while you get a situation where you're allowed to have nothing and you're allowed to have even-handed provision of something, but you can't pick and choose. The number of signatures that you need for an initiative doesn't seem like the kind of thing that would be in that basket.
I see. Professor, always good talking to you, sir. Appreciate your insight. Have a great day. We'll talk to you soon. Thank you.
Good talking to you. Take care.
You got it. Middays, taking a break, coming right back.